Well, hello everyone, and welcome to Uncivil Law. I hope you're having a great day, and we are here with our continuing coverage, and probably will finish it today, of the motion to dismiss in the George Floyd-related killing. So we last covered the principal cop's actions in this case. Derek Chauvin, he is the officer with the knee on Floyd's neck. And we covered his potential liability under second-degree murder statute, and we also covered the dismissal under the third-degree murder statute. We're going to pick up with Chauvin today. We're going to pick up with the manslaughter charges, and then we'll go on to the three remaining officers, Tou Thao, Thomas Lane, and Alexander Kueng. And we'll cover their potential liability in this mess. So, by way of update, when we ended the stream last time, I was very curious about one question in particular. Can you use the underlying assault in this felony murder? Because Derek Chauvin has been charged with felony murder. So murder comes in many different varieties. Felony murder is a particular kind of murder. And it basically says in so many words, if a death occurs during the commission of a felony that you're responsible for, that is murder. So you don't have to have the intent to commit the murder. You have to have the intent to commit the underlying felony, and a death flowed from that felony. So that is felony murder that he's been charged with. And what was a little bit perplexing to me when we last left the action was whether or not you can use the underlying assault, the felony assault, as the predicate felony in the felony murder. And that didn't really make sense to me because of something called merger doctrine. And merger doctrine is basically the idea that if a crime includes in its own definition the commission of another crime, you can't be convicted of both. So you have a crime that includes in its own definition the commission of another crime, that you can't be convicted of both. The lesser crime merges into the higher one. And so an example of where this would happen, incidentally, would be a robbery charge. In order to be guilty of robbery, you have to also implicitly be guilty of theft. You can't be guilty of robbery unless you're also guilty of theft. You can be guilty of theft and not guilty of robbery, but you can't be guilty of robbery unless you're guilty of theft. To prove robbery, you must prove theft. It's a necessary element of the robbery charge. So the idea would be that you can't charge the person with both. You can't charge them with both the robbery and the theft. You have to charge them with one or the other, and of course you would normally pick the higher one. And so that left me a little bit perplexed, because here the felony assault was the underlying cause of death. So the felony assault resulted in the death itself. And so the idea is that because the felony death resulted in a murder, you're trying to use the murder as the predicate felony for the murder, which doesn't make sense. It has to be a different felony. So I went and looked this up in Minnesota law, and I read several different Supreme Court cases from Minnesota to try to solve this. And what do you know? Minnesota just doesn't have merger doctrine. It just doesn't have it. It ruled it like 100-something years ago that they don't have it, and they still don't. So this is the majority rule in like 40-plus states, is the crimes would merge. That is the typical rule, that the crimes would merge, but not so much in Minnesota. So you can, in fact, merge. You don't have the merger problem. You can, in fact, use the underlying felony as the predicate felony, even though it resulted in the death, which is a little bit weird, because it means that you can be convicted of the death. You can be convicted of murder without the underlying intent to kill. Now, in the case of a felony assault, that might be a little bit weird, but you can imagine other felonies where there isn't exactly that same risk, and it would be a little bit weird because you don't have to have the underlying intent to murder, just the underlying intent to commit the felony. But as far as Minnesota law is concerned, that's enough. So all we have to essentially prove here is that he committed the underlying felony, the felonious assault, and pretty much all the elements are kind of already there. That the felony assault was a proximate cause and but-for cause of the death, and he died as a result. And yeah, you're kind of there on the other elements. So the only real issue for the prosecutor is actually trying to prove the underlying felony assault, because the underlying felony assault requires the intent to cause harm. And so his defense would be presumably that he wasn't intending to cause harm. He was merely intending to execute his normal job as a police officer and so forth and so on. But in the end, I think this will be belied by the many, many people who told him that he should stop, and the warnings that he got, not only from Floyd, but many other standers-by and from observers who told him that he wasn't breathing, and another cop who said that he couldn't find a pulse. And even after EMT arrived for another minute, he kept the knee on the neck. So he's going to try to say, I didn't have the intent to commit a felony assault, but, that's probably not going to work. So the odds are not looking very good for Derek Chauvin at this point. So we can reasonably anticipate at this point that he will be convicted of the second-degree murder. Super exciting. So we're going to pick this up in the second-degree manslaughter charge with Derek. Not that it really matters that much at this point, because, being convicted of murder, do you really care about the manslaughter charge? Probably not. The only reason that second-degree manslaughter charge is of any interest at this point to the defense is the hope that the jury will use it as a compromise verdict. That even though they will find the requisite elements for the second-degree murder, they will nevertheless refuse to convict on the second-degree murder and return the lesser count. Which, incidentally, the prosecution may drop the second-degree manslaughter for exactly this tactical reason, to avoid a compromise verdict. So maybe they won't press it all the way through, but that is the only reason for the defense to be interested in at this point, is the hope of achieving a compromise verdict. But we'll cover the second-degree manslaughter, and we'll also cover the other cop's liability, so let's get started with that, and we will pick it up. Oh, it's just a little, yeah, it's not a big deal. No problem. Yeah, not a problem. Just a little nick on yeah, no problem. We're fine. All right. So let's pick it up with Chauvin's potential liability on the second degree murder. Things are not looking very promising in second degree murder land. Are they looking any better in second degree manslaughter land? Let's find out. Under Minnesota law, a person is guilty of second-degree manslaughter if, by the person's culpable negligence, that means culpable is just another word for you're responsible for it, which is kind of implied in the negligence, because you can't have negligence without having a duty. So you can't be negligent unless you have a duty. And if you had a duty and you failed, then you're culpable, but whatever. A culpable negligence whereby the person creates an unreasonable risk and consciously takes chance of causing death or great bodily harm to another, he causes the death of another. Incidentally, this would be second-degree murder in New York. Not that it really matters, but this reckless situation that causes the death of another, it would be second-degree murder in New York. But in Minnesota, it's second-degree manslaughter. So Minnesota is giving you a break relative to New York, I guess. Minnesota statute sets out the requirements of the proof that there was objectively, it's gross negligence. Okay. I made a mistake there because I forgot about the negligence. It's negligence, not recklessness. If it were recklessness, it would be second-degree murder in New York. This is negligence, lower mens rea standard. All right, so we'll just cover real briefly our mens rea elements so that we can talk about what these words mean, because they have definitions in law. So the word here is negligence, not recklessness. So mens rea is your mental state requirement, what your mental state is. So you have the act that you do. The physical act, that's part of the crime. That's called the actus reus. And also you have the mens rea, your mental state, what is going through your mind. And you have to have both in order to be convicted of a crime. And so mens rea comes in 5 different varieties. We have strict liability, which is extremely unusual in criminal law. The most obvious place it pops up, and not in every state incidentally, but some states, is for statutory rape. So yeah, the fact that you didn't know the person was underage doesn't matter. Strict liability, it would be the typical rule there. Well, I don't know if it's typical. I'd have to check the split, but it's common in a lot of states. Next up on the list is negligence. You have a duty to perform some task, and you didn't perform the task, or you failed in the task, or otherwise you created a violation of your duty in a criminal way, and as a result of that, some harm emerged. That's negligence. Next up on the list is recklessness. Reckless conduct is conduct that is so devil may care and so careless and so fancy free that something bad was going to happen. We don't know exactly what was going to happen, but, you can't do this without thinking something bad's going to happen. So that's recklessness, just a complete lack of care to the world, and whatever happens, happens. Not really super promising. Next up on the list for your mental state is knowingly. So to know is to know a particular result will emerge, but not necessarily that you want it to emerge. So that a particular result or particular outcome will occur, but not that you necessarily want that result to occur. And then finally, up at the top of the pyramid, we sometimes call it intent, confusingly, because this entire framework can be thought of as intent. But sometimes we call it intent. Sometimes we call it purposeful, to avoid the confusion. But the very top of the pyramid is either intent or purpose. It was my design and goal that outcome would result. I not only knew it would occur, I wanted to occur. It was my objective that it would occur. So that is your hierarchy, and we're here at the bottom of the hierarchy with negligence. So I have a duty and I violated it. Okay, so what do I have to prove? Objective gross negligence, which sounds suspiciously similar to recklessness, incidentally. So not just negligence, but gross negligence. And subjective recklessness in the form of actual conscious disregard of the risk created by the conduct. So subjective means that the person themselves knew in their own head. So you have to prove that Chauvin, in his own head, knew that there was a risk and he decided to disregard it anyway. The proverbial angel on his shoulder told him this is a bad idea, and he decided not to listen to it. So that is something you have to prove. The objective gross negligence is satisfied by demonstrating the act was a gross deviation from the standard of care that a reasonable person would observe in the act or situation. We all know the reasonable man test. Just take your every man and just ask, what would an every man do? The subjective recklessness component requires proof of the actor's state of mind, what's going through their head, which is generally proven circumstantially by inferences from, for example, words or acts of the actor both before or after the incident. So how do we know what was going through their head? Well, what they did is also a clue, and anything they said either before, during, or after the incident might also be a clue as to what was going through their head at the time. In conducting this inquiry, the fact finder, that would be the jury, may infer that a person intends the natural and probable consequences of their action. Yeah, that's standard black letter law. That's standard black letter law. You can infer the intent from the act. You don't have to, but you can. If the person did the thing, you can assume that they intended to do the thing. You don't have to, but you can. The causation requirement requires proof that both the defendant's act was the proximate cause of injury, it was close enough to count in terms of what he did to the actual injury, as well as the actual cause of death. So that is but for cause and proximate cause. Without this, it wouldn't have happened, and it's not so attenuated it doesn't count. To prove that Chauvin is guilty of second-degree manslaughter, the state must prove the following: that Floyd died, and that Chauvin caused Floyd's death by culpable negligence, whereby Chauvin created an unreasonable risk and consciously took a chance of causing death or other great bodily harm. To cause means to be a substantial causal factor, which just makes it like a but-for cause. Chauvin is criminally liable for all the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were the natural result of his acts. So if something intervened, but it was the result of something you did, then you get blamed for that too, because, it was done by something you did in the first place. The fact that other causes contribute to Floyd's death does not relieve Chauvin of criminal liability, correct? Other things may have happened, the law doesn't care. Chauvin is not criminally liable if a superseding cause caused the death. A superseding cause is one that comes after the acts, alters the natural sequence, so it breaks the chain of causation, and it produces a result that would not have otherwise occurred because it is not a result of something you did. It causes some result that didn't otherwise occur as something you did. It's some Dos Ex Machina thing that's coming from on top to cause the problem. Culpable negligence is intentional conduct that Chauvin may not have intended to be harmful, but so it's not his subjective intent as to this part, right? This part at least, that he didn't intend to be harmful, but an ordinary, reasonable, prudent person, the everyman, would recognize as involving a strong probability of injury to others. How do you determine that? You ask the jury, because the jury is kind of definitionally an ordinary and prudent person. That's one of the reasons the jury exists. How do you determine what an ordinary and prudent person does? Ask the jury. If all 12 of them would agree, That's what an ordinary and prudent person would do. That's how you know the answer to this question. Great bodily harm means bodily injury that creates a high probability of death or causes a serious permanent disfigurement or causes permanent or protracted loss of impairment of death or function of any bodily member or organ or other serious bodily harm. Well, he's dead, so we got that covered. As with intentional second-degree murder, there's no dispute regarding his death, the first element. He is, in fact, dead. We've got that definitely covered. As to causation, the discussion from part 2 relating to his conduct as substantial causal factor applies here as well. So here they're referring to the causation element for the murder. So see the prior video. But yeah, it's like, is he a but-for or proximate cause of his death? There's definitely enough information to lead to that conclusion. And based on the information that is presently available to us, we can reasonably conclude that he is in fact a but-for and proximate cause, and he's going down for murder, and he doesn't look like things are going much better here for second-degree manslaughter either. And that element is the same here as both as the ones above. Yeah, we covered that already. Probable cause exists that Chauvin acted with the requisite culpable negligence. Well, if he act, yeah, it's kind of, you're kind of already there implicitly. If you have the intent for the felony assault. So if you presume the intent for the felony assault, then you're definitionally negligent. Not the other way around. You wouldn't be necessarily intending if you're only negligent, but if you're intending, you're definitely negligent. So if you can prove second degree murder, you got this dead to rights, as it were. So yeah. The only issue to be addressed on this probable cause challenge is whether probable cause exists to believe that his actions constitute culpable negligence, where Chauvin created an unreasonable and conscious risk of causing death. The court concludes that probable cause does exist. First, Chauvin's conduct grossly deviated from the standard of care that a reasonable person would observe in this situation. The state contends that in training given to all Minneapolis police officers, including Chauvin, required him not only to place the subject into a recovery position to elite positional asphyxia, but to do so as soon as possible, to stop using a neck restraint when the subject was not resisting or only passively resisting, and to start CPR if the subject stopped breathing. Chauvin did none of these things, which were presumably his duty at this point. And incidentally, and this is such a little bit interesting thing here when it comes to the police's obligation to do things, because the police typically, as you might well be aware from many coverage, the police typically do not have a duty to anyone in particular. Or to put it even more broadly, the government doesn't have duties to anyone in particular. However, there is an exception to that general rule. And one of the major exceptions is if you're in custody of the government. Because under that circumstance, you cannot provide for yourself, right? You're under the control of the government, so you can't provide for yourself. So the government does, if you're under their control, have a duty. So did the police have a duty to Floyd? Yes. When did it occur? Well, when they started putting him under arrest and they were under his control. So the police did, in fact, have an affirmative duty that popped in from the very arrest that caused his death. Yeah. Yep. Instead, bystanders repeatedly pointed out to all the defendants that Floyd was not resisting, was not moving, and was not breathing. Chauvin continued to press his knee into Floyd's neck. That is evidence of culpable negligence, creating an unreasonable risk of causing bodily harm or death. I cannot disagree. Secondly, Chauvin's conduct reflected actual conscious disregard of the risk created by his conduct. Chauvin could hear bystanders yelling that he was not moving. Chauvin could hear bystanders shouting that he stopped breathing and repeatedly pleading with him to take Floyd's pulse. Chauvin heard Kueng, his fellow officer, twice confirm that he could not detect the pulse. Chauvin could hear Lane tell emergency personnel who arrived on the scene that Floyd was not responsive. Despite all this, Chauvin continued to press his knee into the neck for a full 4 minutes and 40 seconds after he stopped talking and moving. You definitely violated your duty at some point in that exchange, yes. The evidence is more than sufficient to establish a conscious disregard to the risk that he created. Yeah. Viewed in the light most favorable to the state, which is exactly what we need to do at this stage of proceedings, because we're on a motion to dismiss on a probable cause standard, which is extremely low. So as a result, we look at things in the light most favorable to the state. The state will have to, of course, all prove this at trial. But given the best possible posture for the state, at this point, there's more than enough to pass probable cause, because probable cause is a really low standard anyway. Chauvin's primary argument on the second-degree manslaughter charge is that he was acting within his duties to execute a legitimate legal process, and that he was obstructing the legal process of arrest through active resistance. Pretty good argument. It's not going to work because these are factual arguments for a trial. I can tell you already it's not going to work because the jury could believe this, but that is not the question we're going to raise now. The question isn't, could the jury believe Chauvin? That's not the question. The question is, at this particular moment, could the jury believe the state? So what Floyd says his defense are super interesting and all, but at this particular moment in time, we don't care. That's an issue for another day. Chauvin contends that because Floyd had been resisting Lane and Kueng before he arrived and Thao arrived shortly after, and because Floyd continued to resist being placed in Lane and Kueng's squad car during Chauvin's engagement with Floyd, Kueng, and Lane, Chauvin's decision to kneel on the neck, pressing his face into concrete on Chicago Avenue for 9 minutes and 40 seconds after Chauvin, Kueng, and Lane have subdued Floyd into a prone position on the street was reasonable. It may well be. Talk to a jury about it. In particular, Chauvin relies on the law which authorizes the use of reasonable force by police officers in effectuating lawful arrests. This argument fails for 2 reasons. I already know at least one of them. That those arguments are super interesting and all, but at this particular point, we don't care. Tell a jury. Maybe they'll care. They're your ultimate judge. We're just trying to figure out if we can get that far. So, tell it to the judge, as they say, or in this case, tell it to the jury, to be more precise, because they are your judge when it comes to the facts. First, it ignores critical questions for the jury. Right. Whether Chauvin's act of pressing his knee into his neck constituted an impermissible chokehold within the meaning of other law. And even then, if it was not impermissible, whether his actions in continuing to apply force against Floyd by kneeling on the neck for more than 9 minutes and 20 seconds, including 4 minutes and 40 seconds after Floyd had stopped talking and moving, for almost 3.5 minutes after it appears Floyd had stopped breathing, and almost 2.5 minutes after Kueng informed Chauvin he's unable to detect a pulse on Floyd, were reasonably justified. Maybe it is, maybe it isn't. Talk to a jury about it. Even assuming, for the sake of argument, that Chauvin was reasonably justified in restraining Floyd when he, Kueng, and Lane subdued Floyd and pinned him prone on Chicago Avenue, Chauvin cannot escape criminal liability if kneeing on the neck and pinning him face down become unjustified at some point. Right, so even if it was justified initially, it may have become unjustified at some later point and become unjustified to the point it constituted gross negligence. Just because you're doing things properly at one point doesn't mean that you're doing them properly at another point. To bring this out of a criminal law example and to bring it into another example just to illustrate the point, if you were getting operated on by a surgeon in a hospital, just because the surgeon was operating properly and non-negligently at the start of the operation doesn't necessarily mean that at some later point in the operation he wasn't acting properly. So yeah, maybe he was acting properly at the start, but that's not necessarily the end of the analysis. And if you've just been harmed by the doctor in the operating room, the surgeon telling you, well, I wasn't negligent at the start, so we're all good, may be somewhat less than a persuasive argument to you. And so bringing it back to the criminal law context, same kind of analysis. Just because he was justified at the start and just because it wasn't negligent at the start doesn't mean that it didn't become grossly negligent at some point along the way. Yeah. Would Chauvin have someone asked me in chat, Watching Daily asks, would Chauvin have a reliable argument that he would not get a fair trial based on contaminated jury pool? Absolutely, yes. He can make an argument that he can't get a fair trial because of the jury pool, and there are lots of potential remedies for this. The possible remedies include transferring it to a different place within the state so the trial can be moved, although that's considered an extraordinary remedy. The way that this is normally dealt with, though, is just by extending the voir dire process for the jury. So in a typical jury process, I don't know how many people they typically call for a jury in a standard case in Minnesota, but they call some number of people, and the voir dire is the process where you ask questions to the jury to see who gets to sit on the jury. That's the process of asking the potential jurors questions to figure out who gets to sit on the jury. So if one of the ways the courts typically solve this problem is just by extending the voir dire process. They bring more people into the pool, they ask more intensive questions, so forth and so on. But yeah, you can extend voir dire, which is the typical remedy. You can move the trial to a different part of the state, another possible remedy. But yes, he can absolutely raise those issues, and I'm sure he will if he hasn't already. The state contends that it is the case here that he exceeded the force at some point. Whatever the levels of his continuing resistance in the early moments after Chauvin, Kueng, and Lane had subdued him and were all kneeing on him, pinning him to prone to the street, Floyd was continuing crying out that he couldn't breathe. The Lane, Kueng, and Thao videos, as well as Darnell Fraser's cell phone video, shows that Floyd's movement became less vigorous and the frequency and volumes of his speaking began to noticeably decline after about 3.5 minutes. By 4 minutes and 40 seconds, Floyd had fallen silent and became motionless. Nonetheless, Chauvin continued to press his knee into his neck, with Kueng and Lane restraining his back and legs until 8 minutes and 30 seconds, more than 4 minutes and 40 seconds later. Floyd was clearly offering no resistance whatsoever over that time, and any plausible justification for continuing to restrain Floyd in that manner had evaporated. Yet Chauvin continued to kneel on his neck and refused to roll him over to the side in recovery position, even after Kueng, his fellow officer, told him twice that he no longer had a pulse, which is going to really help Kueng and Lane and the other guys in their defense. So the other officers may be scot-free because they were trying to warn him. So the idea that they were aiding and abetting is going to be interesting when we get to their liability. So all the warnings they gave are going to help them a lot. So they might be able to get off of this, but Chauvin's not looking real good here. Wandering Spurring said the jury pool is tainted in the entire Western world. Well, not to put too fine a point on it, but this isn't exactly the first time that in the United States we've had really high profile trials or had to deal with this issue. We've been down this road before as a country many, many times. So, dealing with this and trying to find an unbiased jury is just a more tedious and lengthy process. But it has been done many other times before, and I'm sure it can be done now. So, this is not our first experience with trying to find an impartial jury. I'm sure one can be found even in Minnesota, yes. Second, the jury could find that Chauvin and other defendants' actions in restraining him prone to the street, with Chauvin, King, and Lay kneeling on the neck, midsection, and legs, was not reasonably justified under the circumstances. For one thing, the charge for which he was arrested, passing counterfeit bill, is a gross misdemeanor offense. The jury might find the severity of the crime at issue a nonviolent property crime, thus did not support the level of force he used in others employed against Floyd. That's a little bit more dubious, but yeah, that's a little bit more legally dubious in the end. But for today's purposes, okay. If you're actually convicted on that in the end, I'd be thinking about setting that aside. But that's a little bit legally dubious. But for right now, okay. The jury also found the nature of Floyd's resistance to the defendant's commands did not support the application, or could find that did not support the application of this restraint. Defendants were required by their training to consider whether Floyd alleged lack of compliance was a deliberate attempt to resist or just an inability to comply based on Floyd's self-identified claustrophobia and anxiety, his assertions that he'd been shot before and he was scared and he was recovering from COVID, and the influence of drug or alcohol use, among other factors. Floyd, in fact, had already once earlier ceased his restraint when Kueng had sat down on the sidewalk by the Dragon Walk restaurant. Based on those factors, a jury could conclude that Chauvin should have known that Floyd was at most engaged in passive resistance, and a reasonable officer therefore would not have used this restraint on Floyd. Ultimately, these questions are questions for the jury at trial. Yes, talk to the jury about it, not us. Not for the court to consider in a motion to dismiss for lack of probable cause. Yeah, the jury might believe this. That's their call. But does the state have enough to convict your butt? Yeah, they have enough. Whether or not the jury believes you or some alternate version is their call. But do they have enough in isolation? Yes. No problem. I 100% agree with the court. No problems here. Chauvin's other arguments fare no, except for the one where I was like, yeah, that's a little dubious, but it's a minor point, right, at this point. Chauvin's other argument fares no better. Although Chauvin claims that he acted according to policy and his training, the state disputes this contention, maintaining that Chauvin and other defendants failed to follow the proper use of force policy, did not use proper techniques, failed to consider whether to implement de-escalation tactics, failed to attempt CPR, and failed to inform emergency medical personnel that they had used the neck restraint on Floyd, all of which the state contends their training would require. which would go to show gross negligence. One of the things that can show gross negligence is significant deviation in one area, and another thing that can show gross negligence is a lot of deviations in a lot of areas. So if they're required to do all these things, and then that might go to show gross negligence too. The evidence to which Chauvin points is not to the contrary, nor could it really be at this point. The responsive training guide Chauvin cites that an officer must de-escalate when he or she can clearly defend or control with less force. As noted, the state maintains that Chauvin made no attempts to de-escalate even after he stopped moving or responding or breathing. Chauvin also relies on a photograph of the three officers pinning a subject down in a prone position. So there's a photograph in the manual. This was Tim Pool's point. And, Tim Pool is a fine commentator, but, he's not a lawyer. And, so he wouldn't know this. And, so he could use a lawyer for him. But this was Tim Pool's point. And Tim Pool got all super excited when he learned about this. He's like, the police manual shows a picture of the knee on the neck. Case rule defense, grand slam. I'm like, no. Yeah, there is a photograph of that in the manual, but the manual has other things, Tim. Just because it has the one photograph does not a defense case make. No. So apparently there's a photograph of some of the officers pinning someone down. The photograph demonstrates a particular procedure for getting an uncooperative subject handcuffed when the subject is resisting handcuffing. Here, however, Floyd had been in handcuffs more than 7.5 minutes, and the other defense had made the decision shortly after 8 minutes into the incident to subdue Floyd in a prone position on the street. Lane and Kueng had Floyd handcuffed by 8 minutes and 11 seconds, almost 6 minutes before Chauvin made his first way to Long and Squad, where Lane and Kueng were struggling with Floyd. In addition, the state observes that the photograph on which Chauvin relies also shows that Chauvin's technique while kneeling on Floyd's neck was wrong. Chauvin placed all his weight on his left knee and was pressing his neck rather than distributing the weight as the officer did in their photograph. Checkmate for the defense. No. No. The photo, moreover, is accompanied in training manuals by other warnings. Place the subject in the recovery position to alleviate positional asphyxia. Chauvin not only omits the warning from his brief, because why would he mention facts that are going to be completely horrible for his case, but this court's not that stupid, but also failed to follow the safety procedure when he pinned Floyd face down with his knee, applying significant downward pressure on his neck for more than 9 minutes and 20 seconds. In short, the state notes that Chauvin's own evidence shows that he did not act according to his policy and training. Yeah, no, and that's not good. Yeah, they're not really good. Oh, no, I'm not a Tennessee grad. I'm a Clemson grad. But yeah, it's the wrong color orange. This is more Tennessee orange, but I'm a Clemson grad. Finally, Chauvin contends the state must show, for undergrad, I'm a Clemson grad, of course. Clemson doesn't have a law school. Finally, Chauvin contends that state must show that Chauvin intends the natural and probable consequences of his action. But it's not a separate requirement under the law. Rather, the fact finder is permitted to infer a person intends the consequences of his act. Yeah, that's pretty black letter. The law is clear. The state need not make any particular showing that Chauvin intended the death to prove second-degree manslaughter. Right. That would be weird because, yeah, we don't normally think of intent as a manslaughter element. And manslaughter is almost definitionally murder or death without the intent. That's kind of what manslaughter is as a general proposition. So, yeah, I didn't intend, but we're talking about manslaughter. So, no. Because of what's viewed in light most favorable state, the facts would lead a person of ordinary care to hold a strong and honest suspicion that Chauvin is guilty of second-degree manslaughter, and probable cause exists for this charge. Yeah. So, recapping to finish off Chauvin here, before we get to the other officers, Chauvin's pretty hosed. Chauvin is pretty freaking hosed. There's a lot of circumstances where things are more ambiguous, but this is a little bit clearer. We have a video of the entire incident for the 9 minutes. We have the bystanders shouting the warnings and all that stuff, and it's just not going well. So, the state will try to argue the manual. They'll try to argue that he followed the proper procedure. And they'll try to argue that he didn't have the intent to commit the assault, or that they didn't have the gross negligence. And the state is going to respond by, but look at all the warnings, though. Look at all the people shouting in the video. Look at all the people who told you. Look at all the people who tried to tell you. Look at all the things that you did. How could you not know? And yeah, it's not going super well. So we can reasonably predict at this point that the jury is likely to find guilt beyond a reasonable doubt. Things are not going well for Chauvin. And all the "but he was on fentanyl, though," in the world is not going to help him. No. Okay. So having concluded all those wonderful things and that Chauvin's pretty screwed over here, let's deal with the other officers who may be less screwed because their culpability is definitely way less. So what did they do or what didn't they do? Yeah. Yeah. Yeah, the tone of this is the tone of this memo. I would not characterize the tone of this as prosecutorial. I wouldn't characterize it this way. The tone of this reads to me neutrally. But you have to understand that when you say it's neutral, you have to understand the standard that you're trying to raise. So to say that you're analyzing something neutrally doesn't tell you the standard. So neutral doesn't necessarily mean 50-50, right? That's not necessarily what neutral means. That's one understanding of the term neutral. But if you have a standard, like, you could have a lot of different standards. You could have a standard that, like, when you want to fill up your car with gas, it has to be 100% full. That might be a standard, right? So to fill up your car with gas means it has to be 100% full. That's kind of definitional in the term of fill up the car, but whatever. So like if I asked at a full service station, which, there are some that still exist somewhere. So if I asked for a full service and I asked to fill up the tank and you filled up the tank and then I sued you and I said, hey, you didn't fill up the tank. The neutral arbitrator would be neutral. But the standard that he's trying to figure out is whether it was 100% full. So he's going to be neutral on that question. He's going to listen to both of our evidence on it. But he's not trying to make a 50-50 determination. He's trying to figure out, is it 100% or not? So, you can be neutral and still, like, the standard that you're trying to apply is one way or the other. So at this point, we're on a probable cause standard, which is super favorable to the prosecution. Like, as I've said on a standard of 1 to 10, probable cause is like 1, maybe less. Probable cause is pretty low. It's pretty low. It's just enough to get us out the gate. Do we have enough for probable cause? Without breaking a sweat. So I didn't find this to be prosecutorial in tone. I found this to be very neutral in tone. It's just that the standard that we're trying to reach at this particular stage is very favorable to the prosecution because we're relatively early in the case. Ultimately, we'll be trying to prove proof beyond a reasonable doubt, but we're not there right now. At this point, we're at probable cause. So this was very neutral to me. The judge was completely fair, and I see no problem with any of this. It's fine. And yeah, I know New Jersey and Oregon have full service, but there are a couple full services still sticking around in other states. It's rare, but it happens. Anyways, let's go with the other cops' liability and whether or not they are liable or not, because I think that's a little bit more interesting at this point. All right, so we're going to deal with them all at once. All right. Thao, Lane, and Kueng are all charged with aiding and abetting the crime of unintentional second-degree murder, the felony murder. Okay. The statutory language of unintentional second-degree murder and that of the underlying predicate felony of third-degree assault, as well as the required elements, are set out above. We covered that before. The statute of aiding and abetting, which is the element they're guilty of, says a person is criminally liable for a crime committed by another if that person intentionally aids, advises, hires, counsels, or conspires with, or otherwise procures others to commit crime. The phrase intentionally aids encompasses two important and necessary mens rea elements. Yes, it does. And to prove that they intentionally did it is going to be a little bit harder with respect to the other officers. Did they really have the intent to assist in the commission of a felony? A little bit harder for the other officers. But then again, we're on a probable cause standard. So, we have at least here in Uncivil Law land said not only is Chauvin, we're well inside probable cause. At this point, we are making odds. We're being the bookie, and we're making odds on the premise that he will be convicted. The evidence for beyond a reasonable doubt is pretty solid. The jury could find something different, but it's not super promising. So we will try to analyze whether or not we're past probable cause, and also our feelings, or our thoughts rather, on the probability of conviction in the end, which are, of course, two separate questions. Okay, so the defendant must know that his alleged accomplices were going to commit or were committing a crime. They have to know that they're committing a crime. That's going to be difficult to show for the other officers. Critically, defendant need not to have known of an accomplice's criminal intent before the crime commences. Fair enough. They don't have to know that he's planning to commit the crime. They just have to know he is committing the crime. Because the statute only requires knowledge of the crime at the time of the acts or presence amounting to aid, the assistance, a defendant who acquires the requisite knowledge while the accomplice is in the process of committing the offense can be found liable for aiding and abetting. Yes, you didn't necessarily need to know in advance. If you found out as they're committing crimes and decide to help, that would definitely potentially count, yes. Second, the defendant must have intended his presence or actions to further the commission of the crime. He was trying to accelerate the crime in some way. In other words, defendant must make the choice to aid in the commission either through his presence or his action. Yeah, just because you're there is not going to help. You have to actually take part in some way. Although it's rare for the state to establish a defendant's state of mind through direct evidence, pretty fair, the jury may properly infer the requisite state of mind for accomplice liability through circumstantial evidence, which, is pretty typical in criminal cases. Including, for example, defendant's presence at the scene of crime or a close association with the principal offender before and after committing the crime. Fair enough. As a typical proposition, true. In these circumstances, a little less so. All right, so definition. Under Minnesota law, so this is how the definition would be read to the jury. So these are the jury instructions. Under Minnesota law, read the definition of the unintentional second-degree murder on underlying predicate. So under Minnesota law, here is the crime of second-degree murder. Then, having done that, insert the proper word at this sentence. Thao, Lane, or Kueng, depending on what you're doing at that moment, is charged with the crime of intentionally or aiding the commission. So that's the jury instruction. Okay, great. And then it says, first read the combined elements of the second-degree murder and predicate element. So you have to say what the elements are. And here are the liabilities for the crimes of another. And then let me get past the jury instructions, because we don't really need those right now. Those are just kind of an interesting point of here's how to instruct the jury. We don't need that right now. Under Minnesota law, then, given the nature and charges of the fact pattern here, the facts as we think they exist, to prove that the other cops are guilty of aiding and abetting the second-degree unintentional murder, the state will have to show the following things to be true. That Chauvin committed the second-degree unintentional murder, that's true. You can't aid and abet a crime that didn't otherwise exist. That would be pretty hard, yes. So you have to prove Chauvin's guilty, which, we're kind of there. The other officers, as it may be, knew that he was intentionally committing an assault that inflicted substantial bodily harm. Questionable. That they intended that their presence to be aiding that assault. Questionable. The mens rea element is definitely going to be by far and away the most favorable to these other cops, that they didn't have the requisite intent, the requisite knowledge. Their mens rea is looking a lot more promising than Chauvin's. However, of course, because we're on probable cause, we're at a lower standard. So viewed in the light most favorable to the state, the evidence the state relies on is sufficient for probable cause purposes to charge them each independently for aiding and abetting second-degree murder. Yeah, probable cause is a pretty low standard. And as I mentioned earlier, from black letter law, you can infer the intent from the act. So they did do the acts. We have tape of them committing the acts. So standard black letter law, you can infer the requisite intent from the act. So you're kind of definitionally there on a probable cause standard, yeah. That analysis will not be repeated, but it's fully incorporated as it relates to the probable cause determination of this. Each of the next three sections addresses the evidence on which this court is making the determination. All right, what remains for discussion then is where the evidence establishes probable cause on the remaining two elements. So we're going to start with, we're going to do them each individually now. We're going to discuss them each individually. Okay, fine. So let's discuss Lane. What remains for discussion here is the evidence that establishes probable cause with respect to Lane. Did Lane know that Chauvin was intentionally committing an assault that inflicted substantial bodily harm, and did Lane intend that his presence or actions aided in the assault. These words, intentionally, know, intend, are pretty important in these sentences at this point. There is sufficient information upon which a jury could conclude that Lane knew that Chauvin was intentionally committing an assault that inflicted bodily harm on Floyd. And here's some evidence that might help demonstrate that. Between these times, when Chauvin, Kueng, and Lane first subdued Floyd prone on the Chicago Avenue, each of them kneeling on Floyd has been described earlier in the memorandum opinion. And Lane heard Floyd complaining that he couldn't breathe a couple dozen times, and heard him saying a couple different times he feared would die. As was less than a few feet from Chauvin, he could look to his left and see Chauvin perched atop Floyd, and could hear Floyd as well as bystanders. Lane knew that Chauvin's knee was pressed into his neck. I mean, he did probably know that, that's for sure. I mean, reasonable at least. Moreover, for probable cause purposes, the state is entitled to the inference that Lane actually heard Floyd tell Chauvin, "I can't breathe, please, you're in my neck." Yeah, so what other things did he hear or didn't hear? Which is recorded on the audio of the video. Likewise, the state is entitled to the inference that Lane also heard Chauvin's dismissive remarks to Floyd and Thao's dismissive remarks to bystanders responding to Floyd's repeated cries and claims he couldn't breathe along the lines of, "It takes a heck of a lot of oxygen to say those things. You're talking fine. He's talking, so he's breathing." Which, incidentally, could go the other way, right? That could be inferred by the jury as him having the requisite intent to, like, callously disregard or assist, and it could also be defeating mens rea. It could also be defeating because, now he thinks, now his knowledge is perhaps taken away. So that statement can cut in favor of the defense and can cut in favor of the prosecution. Those facts alone are sufficient to raise a fact question as to whether Lane had the requisite knowledge that Chauvin was assaulting Floyd. Yeah. There's also sufficient evidence from which a jury could find that Lane knew that Chauvin was inflicting substantial bodily harm on Floyd in the minutes as they passed. The amount of time here is going to be a factor that is going to run against them. By some point on this, Lane had been engaged directly with Floyd for 14 and a half minutes. He knew how vocal and physically active Floyd had been over that period. But then, Floyd had fallen silent and stopped moving. As time continued talking by, Lane heard Kueng tell Chauvin he could not detect a pulse and could not hear the increasingly insistent comments from bystanders that Floyd had become non-responsive, was not moving, was not breathing, and repeatedly demanding dependents check his pulse. The woman representing herself as a Minnesota firefighter even yelled that they should begin CPR if they could not detect the pulse. There is evidence from which a jury could find that Lane knew Chauvin's kneeling on the neck was inflicting substantial bodily harm. I guess you could infer that. It's a bit of an uncharitable inference, but it is one that's allowed for by the facts. Lane's own comments at the time confirmed that they were aware Chauvin was intentionally and unjustifiably causing substantial bodily harm to Floyd. For instance, as Floyd started to show signs of loss of consciousness, Lane asked Chauvin whether they should roll him on his side because he's worried about the excited delirium or whatever. Less than a minute later, Lane remarked that Floyd was passing out. Another minute later, Lane asked again whether the officer should roll him on his side. As bystanders were yelling, Floyd was not resisting or moving. Lane asked Kueng if they were able to detect a pulse. Kueng checked twice, responding negatively both times. Even though Lane knew from his training that Floyd was in an inherently dangerous position, that he'd ceased talking, become non-responsive, they no longer had detectable pulse, and that some of the gathering crowd were shouting that Floyd was not breathing, Lane persisted with Chauvin and Kueng in keeping him pinned to the pavement face down. Yeah, you could go either way, but I think the defense has a much better chance here with these guys because they deferral to a superior officer, deferral to someone with more training. They didn't really know what was really happening. So Chauvin is screwed, but Lane and the other officers are looking a lot more promising on the mens rea elements. When emergency personnel arrived to provide aid, Lane acknowledged that Floyd was not responsive. As Lane later told investigators, by the time EMT arrived, he was concerned that he may be dead. Lane's comments show that he knew, or might show that at least, they had not been resisting for some time. Watching you daily says medically in determining whether someone is actively breathing in the field by EMS, if they're talking and it appears to be clear and not labored, they're considered breathing. I don't know what any of those words mean. But I mean, that sounds wrong to me because it depends what you mean by labored. But, I think that there was enough evidence to see that his comments were labored. So I think the video would reveal that his speech was labored. Let's see, where were we? So Lane comments show that he knew he had been not resisting for some minutes and did not appear to have a pulse. His questions about changing body position by rolling him over demonstrate knowledge from his recent training about inherent dangers of neck restraints used on detainees in prone positions. He's trying to alert someone to the problem and also backing up his fellow officer. Lane had solid contemporaneous real-time evidence that Chauvin's action in continuing to press his knee into the back of the neck were in fact harming Floyd. These facts together establish probable cause to believe Lane knew Chauvin was intentionally inflicting substantial bodily harm. Finally, Lane's training reinforces that he knew Chauvin was applying unlawful force. Lane was a new officer, so his training was recent. Yeah, wasn't he like a week old? Wasn't he like under a week old? When we say new, we mean really new. Yeah, so he was really new. Minnesota police officers were trained to place the suspect in recovery position to alleviate the asphyxia. They are told neck restraint is not permissible on a subject who's passively resisting or not resisting at all. They are told to check the subject's airway and breathing and to cease neck restraints and start CPR if the subject stops breathing. Chauvin and Lane, however, ultimately disregarded all that training. As a probable cause standard, yeah, but at the end of the day, less convinced. The question Lane repeated twice to Chauvin and Kueng, should we roll him on his side, shows Lane remembered his training, from which jury would be justified in finding he knew his actions were unjustified. Second, the evidence is more insufficient for a jury to conclude Lane intended to aid him in the assault. A jury may properly infer the requisite state of mind through circumstantial evidence. Such evidence may include the defendant's presence at the scene of the crime or close association with the offender. Here, the circumstantial evidence is stronger. Lane, Kueng, and the Frazier video demonstrate that Lane was using his knees and hands to pin down his legs for the entire 9 minutes and 20 seconds that Chauvin has his knee on the neck. Lane continued to restrain Floyd in conjunction with Chauvin almost 4 minutes after he told the other officers he's passing out, or 2.5 minutes after Kueng told Chauvin and Lane for a second time he'd been unable to detect the pulse. Indeed, Lane continued to maintain his position even as onlookers pointed out that Floyd was not breathing, moving, or resisting. And they held him that Chauvin was responsible for stopping breathing and he was going to kill the man in front of you. And even after an ambulance arrived on scene to provide medical aid, Lane also waved off an off-duty emergency firefighter who sought to provide assistance, telling her to go up the sidewalk. Not that he'd necessarily know that she was a firefighter. I mean, she said it, but I don't know that she presented ID or anything. And also, the police need to secure the situation. That would be standard behavior. Anyway. In taking these actions, Lane made the choice to aid the offense commission. At a minimum, his actions enabled Chauvin to maintain control and knee on the neck. A jury could therefore conclude he intended the presence to act or further the assault. That conclusion also follows from Lane's question to other officers and his subsequent actions as Floyd was losing consciousness. As previously noted, Lane twice asked if they should roll him over on the side. Lane not only asked him to check the pulse, but also told investigators he might check the pulse himself. Those questions demonstrate Lane knew not only the proper protocol, but also the consequences of keeping him face down on the ground. Nevertheless, Lane ignored all that, deferring to his other officers and stuff like that, reapplying pressure on the legs after hearing the other officers' responses. Lane never began to perform CPR once Floyd stopped moving or breathing before the ambulance arrived. Lane never attempted to move Floyd in a different position on the ground. Equally important is another thing Lane never did. At no time after the ambulance arrived and the EMT set up the stretcher next to Floyd did Lane try to extract himself from the situation or assertively remonstrate with Chauvin to stop pressing on the neck. Viewing all actions in light most favorable state, a jury could reasonably conclude they intended in the assaulting of Floyd. Those are some very uncharitable conclusions at the end of the day on this fact pattern, but the ones a jury could conclude. For probable cause purposes, sure, because the standard is very low. For proof beyond a reasonable doubt, Lane's chances are looking a lot better. The requisite intent, it seems to be problematic, in my view, at this time. On summary, on each of the elements of aiding and abetting, the evidence is more than sufficient to present a fact question. That's true, I suppose. There's therefore a probable cause to believe they committed the offense. The principal argument in this motion is they didn't have knowledge that Chauvin was committing a third-degree assault because the decision to restrain Floyd was reasonably justified. According to Lane, Floyd was uncooperative and actively resisting. Thus, Lane contends Chauvin gave Lane license to pin him face down even for minutes after he had no longer moved. Lane's argument fails for two reasons. First, it ignores the critical question for the jury, whether the actions of Lane and his co-defendant were reasonably justified for the entirety of the interaction. Yeah, fair enough, but even if the state were to concede defendants were reasonably justified in restraining in the manner they did when they first did it, doesn't necessarily mean that it was justified later. See our surgeon operating example from earlier. Do you people really think that Chauvin wanted him to die? No, I don't. I don't think Chauvin wanted him to die. But I don't have to think that. We discussed that. We're not here on intentional homicide. We're here on felony murder. No, I don't think Chauvin. Well, I don't know either way, but it doesn't matter. You can fully believe that Chauvin didn't intend him to die. It just legally doesn't matter. He's not charged with intentional homicide. He's charged with felony murder. So you don't have to believe he intended him to die. What you have to believe is that he intended to inflict the felony assault. So, or in the alternative for the manslaughter, that he was in gross violation of his duty and consciously disregarded a known problem, even though he was aware of it. So, yeah, not looking real good for Chauvin right now. Not really good right now. Can I explain this again? Which part? Like it's like listening to Kamala Harris talk? Really? Jesus Lord. Oh, with you people. I thought you meant me. Ugh. All right. So let's just go back up to the top of it. Yeah, we can recap. We can recap with Chauvin for a while, just to bring everyone up to speed. Okay. All right. So let's recap for Chauvin and his liability. So we are charging Chauvin, the guy with the knee on the neck, with 2 crimes. We are charging him with second-degree felony murder, and we're charging him with second-degree manslaughter. So to prove second-degree felony murder, we need to show that Chauvin committed an underlying felony, and that felony resulted in his death. We don't have to prove he intended the death. We have to only prove the intent to commit the underlying felony. That's felony murder for you. It is I don't know if it's unique to the United States, but it's relatively rare. It's been questioned by many people, but it is fairly common in the United States. The idea is that you've performed some inherently dangerous act, and if people die as a result of your inherently dangerous act, well, sucks to be you, even if you didn't intend those people to die, because you're the one who started this party in the first place. So to find Chauvin guilty of felony murder, we need to prove that he intentionally inflicted the felony assault. We covered those definitions from earlier, and basically, in so many words, that he intended to cause what's the proper language? Gross harm to the body, permanent impairment of an organ, permanent impairment of some function, or stuff that is of similar caliber to get to felony assault. So we have to prove that Chauvin committed the underlying felony assault, then he died from a result thereof, and we're kind of there. We're kind of there without breaking a sweat. To prove Chauvin guilty of the manslaughter, we have to prove that he had a duty to act or not act, that he violated that duty in gross negligence. Objectively and also subjectively, he was consciously aware of a risk that he consciously decided to disregard. So did he have a duty to perform? Yes. The cops generally do not have a duty to anyone in particular, but they do have a duty to people that are under their control or custody, as Floyd was at the time. So Chauvin did have a duty that was operative at this time. Did he violate his duty? We covered those standards in the relevant manuals, the various ways that he may have violated his duty in many different ways. Was he consciously disregarding a risk? Well, everyone was kind of warning him actively of the risk, and yeah, he kind of consciously disregarded that. So we're kind of there on second-degree manslaughter. So Chauvin is kind of completely hosed. He's completely hosed. The defense is counter. The defense is going to counter by saying, well, Chauvin was trained to use these procedures, and they're going to look at the training manuals, and they're going to say that he wasn't aware he was only trying to do his duty as he had been trained, and they're probably going to try to attack the medical examiner's report as best they can, and so forth and so on. But the state is going to rebut by saying that, after 8 minutes and 20 seconds of people screaming in his ear that he was killing this guy, that, it was long past the point of no return. And so the jury, guilty. So he's totally screwed. Totally screwed. So that's where we are. Oh, and then there was also the merger issue that we discussed earlier, because there was this issue that I raised on my last time where I did the second-degree murder charge, because in many states there would be a problem with what's called merger theory. But long story short, Minnesota doesn't have it. It's like one of 8 states that doesn't have merger theory. So even like in most states, you couldn't charge this felony murder. You couldn't use the assault as the underlying felony to the felony murder. So in like 42 states, you can't use the underlying felony assault as the felony for the felony murder. But Minnesota apparently has no problem with it. After my stream last time, I went and read like several Supreme Court cases from Minnesota. And Minnesota's totally cool with this, not having merger. So, well, there's the end of that analysis. So, that is where we are at this point. The assault does not merge, unfortunately. No, I was raising that question last time because I couldn't believe it. And then I went and read like several Minnesota Supreme Court cases, and they're like, oh, no, it doesn't merge in Minnesota. That's really, really weird. Why not in Minnesota? Minnesota apparently has no problem with this. Railway Hacker says it surprised him. It surprised the heck out of me, man. Internet commentator asks one of the right questions. Internet commentator says, internet commentator asks one of the right questions. The right question is, but for what Chauvin did, would Floyd died? Railway Hacker is incorrect in asking the question, but for the fentanyl, would have Floyd died? That's irrelevant. You can have multiple but for causes. It's not like there can only be one but for cause. To say something is a but for cause is to say that but for this thing, it wouldn't have happened. You can have multiple but for causes. So the question isn't, did the fentanyl kill Floyd? That's not the question. Maybe the fentanyl did kill Floyd. That is not the question. The question is, did Chauvin kill Floyd? And both can be true. And so if the fentanyl killed Floyd and Chauvin killed Floyd, he's guilty of murder. So, yeah. If the fentanyl alone wouldn't have killed him, nor what Chauvin alone would have killed him, but combined it killed him, Chauvin's guilty of murder. You take the victim as you find them. Don't commit crimes. All right, where were we? Let's see. Lane is Lane is guilty of aiding and abetting a third-degree assault, the predicate felony here for the unintended second-degree murder charge, so long as he acquired the requisite knowledge while Chauvin was in the process of committing the offense, which is debatable. Stated otherwise, because again, knowledge, as I was trying to summarize earlier, knowledge is to know a particular result would occur. You know it will occur. And because he's getting a lot of conflict, so there's evidence that would suggest that he knew, because there's a lot of things from the crowd and a lot of things that he was saying that suggest that he knew. But there's also things that would suggest he didn't know, because there's other information, from his other officers, his training, all this thing. So what was actually the state of his knowledge? Did he actually know this would result? I mean, he had some knowledge that's like, maybe it's a problem, but some knowledge that's going the other way. So was he able to actually get to the point where he's like, I know that this result will occur? For Lane, that sounds a little bit dubious to my mind. Stated otherwise, the 3 officers continued to restrain Floyd prone on the street, with one of the officers forcibly pressing his knee on the neck, adversely impacting the capabilities of the respiratory system, at a point after which it became unjustified, and Lane actually knew as much. He cannot escape liability. Yeah, that's assuming a lot of stuff, though. But yeah, if all that stuff is true, then that would be correct. The court also already detailed the evidence upon which the state relies for its contention. The defendant had no reasonable justification for continuing to apply the same levels of force and same means of restraint 4 minutes after Floyd had stopped even passively resisted, stopped talking, stopped moving, and as it turns out, had stopped breathing and slipped under consciousness. Washington Daily says, well, then the police interaction with all the other officers could have killed him as well because the fear compounded with the excited delirium. Well, if Chauvin was the one in inflicting the fear, then he's got some serious problems. Yeah. So, yeah, the fear is what killed him. Was Chauvin the one creating the fear? Yeah, that'll be a problem. The court has already detailed upon which the state relies for its contention. Defendant had no reasonable justification for continuing to apply the same level of force and same means of restraint for minutes after Floyd had stopped passively resistant, stopped talking, stopped moving, and stopped breathing. The state maintains there's no plausible justification for the defendants to have continued restraining Floyd after he'd gone silent and motionless, yet they continue to do so. Viewed in the light most favorable to the state, probable cause exists. Secondly, and in any event, the jury could find the officers were not reasonably justified even after the initial moment they restrained Floyd face down on the ground. The state's rationale and evidence were discussed above. Lane's other arguments for dismissing fare no better. Lane contends he relies on the experience of Chauvin. Yeah, this is exactly where, this is going to come in for Lane big time. So Chauvin's arguments sucked. Lane's arguments are going to sound a lot better. Lane contends that he relied on the experience of Chauvin, a 20-year veteran who told Lane on only his 4th day, pretty good factor for Lane, to hold Floyd where he was. But there's no free pass for rookies who choose to disregard the training at the suggestion of a senior officer. Yeah, that's very technically true, but Lord, man, is the jury really going to be able to get there? I don't think I would. Really, man, Jesus Lord. I mean, policy itself compelled Lane to do what was right. It shall be the duty of every officer present at any scene where physical force is being applied to either stop or attempt to stop another sworn employee when force is being inappropriately applied. On his 4th day? On his 4th day, you really are expecting this? I know he swore to do it. I know it's his role, but it's his 4th day. So you really are expecting this guy on his 4th day to forcibly stop his 20-year superior? Does that sound like a thing that makes sense? Man. As Lane, even if 25th was only his 4th day, after the completion of his training, he had extensive training prior to his death. He'd been hired 15 months earlier and spent about 5 months receiving training at technical college. Well, that's just as good as real-world experience. Lord have mercy. 4 years after the police academy and 4.5 months in the field with other officers. Lane's questions to Chauvin signaled that Chauvin had disregarded the training. It wasn't that he didn't know, it's that he failed to act appropriately on what he did know. Man. I mean, on a probable cause standard, the court is right, but to think that the jury is actually going to be able to get there at the end of the day, man, Jesus Christ. You know, it really feels like the state shouldn't be pressing this charge, to be quite honest. I mean, you know, the prosecution does have to have a good faith belief that they can get to beyond a reasonable doubt. They can't just bring stuff on a probable cause standard because they can. So they have to believe they get beyond a reasonable doubt. They really think they can get beyond a reasonable doubt on this fact pattern? Man. Discretion would suggest not bringing these charges in this circumstance, even if it's a technical violation. So this is one of the reasons prosecutorial discretion does exist. It's like, even if it's a technical violation, is this really what the law was trying to encompass, man? I don't think so. You know, I know it's a pass, but Jesus, man, jeez. In light of Lane's training and his manifest disregard, viewed in light of the most favorable state, yeah, the evidence establishes probable cause, reserving for the jury at the time the ultimate determination whether it was reasonable. I hope they will, man, Jesus Lord. Although Lane expects it would have been total chaos if he decided not to follow his instruction, he points to nothing in the record to support that bare assertion. Wow. I mean, there isn't anything in the record, but does it take a lot of imagination? I mean, we all have imagination, so sure. There's nothing in the record that shows that if he had done this, it would have caused chaos. But, you know, we do have a brain. Lane could have disregarded Chauvin's instructions either at the time they were given or after Lane learned that Kueng was unable to find a pulse and demand the officers turn him or use a hobble restraint. They could have tried to perform CPR once he realized his non-response. There's no reason to believe such responses would have created any more chaos than defense actions did. Oof. Rough. Oof. That's rough. In any event, under Minnesota law, the consideration is largely irrelevant in determining if he's liable as accomplished. By statute, Lane can can escape aiding and abetting only if abandoned the crimes, which has a very technical definition, incidentally, and made reasonable effort to prevent the commission of the crime prior to its commission, which, no. Lane does not contend that he abandoned or made reasonable effort to prevent it from happening, and the evidence from the video make it clear he does not. Instead, rather than abandoning the crime or preventing, Lane furthered it by continuing to hold him down. Oof. Finally, Lane contends the force used by Chauvin by kneeling was not substantial because there's no findings of asphyxia by presumably the medical examiner, which, is not the issue for right now. That contention misses the mark, and Minnesota law regarding the third-degree assault does not require the force used to be substantial. It requires bodily harm to be substantial. No one is contesting Floyd suffered substantial bodily harm because, he is dead. Lane's contention also misconstrues the record before the court. It appears the 2 autopsy reports commissioned by the Floyd family conclude that the cause of death was asphyxia due to neck compression applied by Chauvin. The HCME report concluded that Floyd's death was caused by law enforcement subdual restraint and neck compression. An independent consult by Armed Force medical examiner resulted in a report which the officer endorsed the autopsy finding and thus certification. Also noticed that the subdual and restraint had elements of positional and mechanical asphyxia. This is strong evidence of harm. Chauvin may, of course, contest these findings, and if he chooses to present his own expert witness at trial, good luck as to Chauvin. However, for the present purposes, the task of weighing this evidence in light of testing by adversarial process and parties' argument is for the jury, not for this court. Well, the court is right, but man, if Lane gets convicted after this, man, Lord, jeez. Yeah, as to the crowd, here the answer is pretty easy. As I mentioned earlier, there's no affirmative duty to act. That applies to the police and civilians alike. So the reason that the civilians are not liable for anything is because they have no duty to act. You have no duty to stop a crime in progress. You can watch a crime happening and just go about your business. You can watch a person suffocating another person to death and just walk on by if it's what you want to do. There's no affirmative duty to act. So the reason the crowd isn't liable is because they have no duty. The reason Lane is potentially liable is because he does have a duty. And why does he have a duty? Because even though the police, generally speaking, don't have a duty to the public at large, they do have a duty to those people who are under their custody, as Floyd was. So Lane did have a duty in the circumstance under the operative law. So, okay. And I saw some of you guys in the chat are ready to convict Lane over here. I just feel that's an overly harsh conclusion. I mean, trying to put yourself in that shoes, I'm just trying to put yourself in those shoes. And can you really imagine yourself after 4 days on the force, you're 4 days in the field, and this 20-year veteran is telling you to do particular things? You can really see yourself, being the one that yells at him to stop and tries to force him to stop. You can really see that happening. I mean, I know we all want to imagine that we would be the hero when the moment came, but the reality is most of us won't. It's much easier to not be. For every Oscar Schindler there were millions of people who just went along with the Nazis. It's much easier to get along. So I'm not saying the police are Nazis. I'm using it as an analogy. So don't mistake my point there. It's just it's a lot easier to get along. And so for all you guys who are ready to convict the 4-year guy, man, you're harsher than me. That's all I'm saying about that. All right. So as to some other people here, as we're on page 91, let's see if there's anything that we need to discuss specifically with respect to Kueng. So let's see. We'll skim this because we kind of got the gist for Lane. So the other 3 officers are going to be substantially similar. So we'll skip. We'll just see what's going on. So what did Kueng do? Vote in the life most favorable. Kueng knew that he intentionally inflicting harm. He heard Lane asking, commented about stuff. Bystanders were giving him knowledge. He had also just recently completed training. All the evidence points that the actions earlier, as well as the evidence established Kane for almost 4 minutes. Kueng had been unable to detect the poise, continued to maintain his position, holding down his back in midsection. Well, I mean, that will do it. That's a physical act. That's enough to get him liability. So basically just take everything we learned about Lane and apply it to Kueng, and you're there. So we don't need to read that twice. And then as to Thao, Thao's in a somewhat different position because at no point was he involved in the efforts to physically restrain. Okay, so then his liability becomes a lot more dubious because what did he do to aid? Rather, his role was to maintain watch over the growing crowd, to use Thao's own phrasing, as a human body cone, interposing himself between himself and his fellow officers. For almost 6 minutes, they restrained him. Thao was standing far enough back in the street he could see everything that Chauvin was doing in restraining Floyd. Not that he was necessarily looking, because he was also looking to the crowd. Although Thao also did move forward to the curb at Chicago to position his body, kneeling on Floyd, he remained only 2 or 3 feet from where his nailing it could be occasionally seen to turn his head from the crowd assembled to other people. In reality, Thao hardly needed to turn around and watch for himself. He was getting second-by-second play from assembled bystanders, and was close enough that he could see everything that was being said. So he has some knowledge from the bystanders. They screamed at him. That would give him the requisite knowledge, presumably, or not. That's a question for another day. Thao knew from his training, or at least a jury could infer, that continuing to kneel on the neck would be a violation of policy and could not be considered good use of force. Although Thao had been on the use for 4, he acknowledged in the interview he'd been trained on how to. For years, he acknowledged in his interview he'd been repeatedly trained to use neck restraints. And his comment when 4 officers were considering whether to use hobble restraints is that they apply to hobble, a sergeant is going to have to come over. Thao was fully aware from his own direct personal observations, as well as he heard from a group of bystanders, Chauvin had continued kneeling for a substantial period of time. This suffices to present a fact issue to the jury, as well as whether he knew about the knowledge. State also presents sufficient evidence for jury determination's intent by his presence or actions to aid. A jury is permitted to infer state of mind. Thao had earlier suggested that Floyd be hogtied. They'd also located Lane's hobble device in the first minutes after the other 3 had pinned him, and engaged in a discussion as whether they should use the hobble. And they didn't want to because it meant a sergeant would have to come over to examine it, so they didn't want to have to bother with the paperwork. All right. A reasonable jury could conclude from this that Thao was more concerned about avoiding paperwork and administrative work than he was about Floyd's safety, by virtue of the dangers Floyd faced from the manner of the knee on the neck. The jury could find sufficient evidence that Thao provided aid, counsel, as well as conspiring with him to assault Floyd. I take a little bit of objection with conspiring, because conspiring kind of requires an agreement between the parties. So, when did they ever really agree? They agreed by their mutual action? I don't know, man. Thao's actions as a body cone prevented any of the bystanders from coming onto the street and forcing them back on the sidewalk as soon as any of them stepped into the street. Thao also took a lead role in rebuffing the off-duty Minneapolis firefighter who arrived at the scene and asked to be allowed to provide medical assistance. Thao's actions in keeping the bystander on the sidewalk and preventing any of them from intervening in continuing the assault. It does not matter that, unlike the other defendants, Thao himself never physically touched Floyd. Active participant in the overt act constitutes substance offense. Here, the assault is not required for aiding and abetting. That's true. Indeed, the law is a lookout, someone who stands nearby and does not make direct contact, but seeks to prevent others from interfering in the crime, is a classic example of aiding and abetting. Yeah, but typically a lookout is, established in advance of the crime, not on the fly. But okay. Because Thao's actions enabled Chauvin, Kueng, and Lane to maintain their restraint, with Chauvin's continuously pressed to the neck, a jury could find the factors they need. And then, for aiding and abetting the second-degree murder, is probably going to be basically the same thing. Because, if you can get to second-degree murder, which we basically discussed already, you can get to second-degree manslaughter, that they aided and abetted, that they knew that it was reckless disregarding, and etc. and so forth. And they had training that gave them the requisite knowledge. They were in conscious disregard, the gross negligence of the standard, and etc. and so forth. So that brings us to the end of all that. So that brings us to the end of discussing this. So Chauvin is totally hosed. His fellow officers have a much better chance. Yeah. So Chauvin is totally hosed. His fellow officer has a much better chance. Because the real issue here is the intent to aid and abet. Chad said, so if I grab a guy off the street as a lookout, he doesn't have culpability during a robbery so long as we don't conspire. Well, I'm not really well, does this guy know that you're committing a robbery? If you just grab a guy as a lookout, then unless he knows that you're committing a robbery, he's not aiding and abetting the robbery. So, like, in this hypothetical universe, you're going up to a random guy and you're pulling him off the street and you say to him, I'm about to go in here and commit a robbery. Will you please stand as a lookout for me? And he says, okay. I mean, well, first of all, you have a conspiracy at that point because you had an agreement and now he's about to commit an overt act. So at that point, once you've said, okay, there's a conspiracy. And second of all, in this abstract hypothetical, then yeah, sure, the guy would be guilty as a lookout. But, that probably doesn't happen a lot in the real world. I mean, I'm not this biggest expert on criminal law, but I'm just imagining that there's not a lot of ad hoc on the fly lookouts. I'm just going to guess. So, but yeah, I think the liability for the other three is a lot better. So, because the requisite intent, requisite knowledge, because you have to have intent. You have to have intent to help him commit a crime, which means that you know that he's committing a crime. And again, because your position is different, your state of knowledge is different. So the knowledge element is a lot harder for the state to prove here with respect to the other officers. So we'll see. Dan says, how could the officers have any reasonable ability to know Chauvin was doing something illegal? Was it shown the tactic was against police policy? The way the state argues it is, yeah, that they didn't follow the policy. But, like, even then, like, did they really have... To say that you were in violation of policy, even to say that you're using excess force, does it mean that you know that he's committing a crime? The requisite mens rea is a little bit more tricky. A jury could find it, but a jury doesn't have to. So... so we'll see. But Chauvin is totally host. Chauvin's host. Jury can get to reasonable doubt. No problem. So if they find Chauvin not guilty, that would be pretty surprising at this point, given the amount of evidence that's available against Chauvin. But if they find the other people not guilty, that would be less surprising. So you could see some split verdict like that. And also, like, the judge could dismiss the charge anyway. So you have a couple other opportunities for the judge to dismiss the charge. So he hasn't dismissed it now, but he could dismiss it at the end of the state's case. Probably not. And then he can also dismiss it after the jury comes back with a guilty verdict, which would put the judge's ass really on the line. But he can allow it. Judgment notwithstanding the verdict, JNOV it. Instead, jury says guilty. How about not guilty? That should make people super, super happy. But I wouldn't be surprised if there's not guilty verdict for these other officers. So I will just respond to any... 999 from Ghost to Recon gave me a super chat saying, here's for your awesome analysis. Thank you, Ghost to Recon. I'll just respond to a couple super chats. Some of you guys are really, really mean against the officers here, against these other officers. I mean, I feel like you need to put yourself in that position and figure out what you would have really done or what you really would have really known. So it's a little bit, I think you're being a little bit aggressive in some of your conclusions. I'm not saying you can't get there, but it just feels a little bit aggressive. Should Lane's case be dismissed at this point? There's enough for probable cause. It's probably not a good idea to dismiss, but I could see a judge who's ballsy dismissing it at some later point. Like, dismiss it at the end of the government's case or dismiss it after the jury comes back with a guilty verdict. That would be super fun. Chauvin has another defense. It's called inattentive blindness. Well, that he didn't know or didn't have the intent. I mean, yeah, but he's going to have a really tough time with that because it went on for so long and he got so much information. It's really like it's going to be really hard for Chauvin. I'm not saying he can't get there. I just think he's going to have a really bad day. Yeah, Tony K said, I'm confused. For felony murder, I did not think the asserted assault could be merged, and therefore second degree may not be applicable. Yeah, you know, me and you, Tony, we both misunderstood. I thought, yeah, it would merge, but in Minnesota, not so much. So in Minnesota, this flies. In like 42 states, it wouldn't fly, Tony. But in Minnesota, this flies. There is no merger doctrine. So you can, in Minnesota, even though you can't in like 40 other states, you can in Minnesota use the underlying felony assault for the felony murder. I was also very surprised. But I went and did the case law research, and yep, that's the rule in Minnesota. Surprisingly enough, I was surprised. Is the state deliberately going for a mistrial? No, I don't see that. And the jury can also come back with partial verdicts. Um, they could the jury could come back with verdicts on some charges and not verdicts on other charges. So I doubt we're going to see a mistrial across the board. I think you'll get convictions for Chauvin. You could see non-convictions or hung juries for some of the other charges, but that's fine. Some of you guys are just really, really mean to some of these other officers, but you know, that's fair, I suppose. Different people can disagree. Aluminum Tech points it right. I couldn't see myself questioning a 20-year veteran cop if I was 4 days off the vet. Yeah, that's kind of where I was. You know, no, it's not a Whataburger shirt. I should get a police union rep on the channel. Why? What is a police union rep going to tell me that I don't already know? These are legal determinations. Was a police why would what would a police union rep tell me that I don't already know? I mean, the court just educated me as to the facts and as to the law. What would a police union rep be able to tell me? Why should I get one? Why would it help? Um, I think that was all the comments. All right, so I'll end the stream. Watching Daily says the inattentive blindness, he was so involved in his normal perception of the events that his events were clouded. All I have to say is good luck to that argument with the jury, man. That's what I say, you know. For labor law stuff, yeah. Is there a Monell claim? Monell's civil, man. That's the civil law issue. We're on criminal law. I think they already settled on the civil issue, didn't they? They already settled civilly. So there's no Monell's a civil law thing. Qualified immunity also has no bearing on criminal law issues, so we don't need to do a qualified immunity analysis here. All right, so I'm going to sign off, guys. I hope you liked it. I hope this was a good stream. If you haven't already done so, please like. If you've not already done so, please subscribe. If you haven't already done so, hit the join button. I hope this was helpful. I hope you learned a lot of things. I learned a lot of things. We will definitely keep up with it as we learn more. And till later, my friends, cheers and goodbye.